you don't ask if a 5-year-old can work,
Correct. So you can't win. You can't
Well,
get past the listings. It's yes or no, and if it's no, you lose. If it's yes, you win. And so that's what makes it harder. And then the second part of kids' cases that make it hard is not only is it medically do you have to meet a listing, there's a financial criteria because it's SSI, because the kid has not paid into Social Security. We don't expect 5-year-olds to pay in Social Security. So then they look at the parent's income.
mm-hmm.
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Like a cashier at the grocery store, grocery store clerk, someone like that.
Or a flagger. Yeah, there are, and a lot of, I think fast food workers considered light work.
Yeah. Same.
Yeah.
But maybe shorter cooks I thought are medium. I don't know. I have to. Let's move on. Number 7 was Lyme disease.
Oh, yeah. Lyme disease. If you can prove that you have Lyme disease is, I think it's generally considered incurable, but it kind of has relapsing, and you might get better for a while, and then it can come back over time, and you never really get rid of it, I think. I mean, I'm not a doctor, but that's what I think.
What makes it difficult to win? Is it the same as kind of it's a bias thing, or is it proving it, or what makes it difficult to win in front of a judge?
That's a good question, and I think that it's because of the interface of Lyme disease with a lot of people have been bitten by ticks, and so they'll be, oh, well, I have Lyme disease, but maybe they didn't have Lyme disease. The testing for Lyme disease has changed a lot in the last 5 or 10 years, I believe. And some of the testing they used to do is no longer accredited. It would depend, I suppose, on the validity of the testing, whether it's pretty much, up to snuff, so to speak. And also, whether the impairment that the claimant is claiming might be chronic fatigue or something like that. I don't know. Lyme disease is still, I'm not an expert on Lyme disease, that's for sure, but I don't know many people that are, frankly. Rheumatologists maybe.
A lot of times what you'll see in these cases, in a case like fibromyalgia, chronic fatigue, Lyme disease, you'll see a grouping of diagnoses together. Like, oh, this person is diagnosed both with fibromyalgia and chronic fatigue, or Lyme disease and fibromyalgia, and it muddies the water a bit, because even though their doctors are sort of throwing in everything of what they truly believe the diagnoses are, I think from a judge's perspective, they're like, well, which one is it? Especially if you get a judge that's kind of leaning towards wanting to deny people versus wanting to award people. You kind of that situation too. It's like, well, look, you can't prove that it's fibromyalgia, chronic fatigue, or Lyme disease because they just threw all 3 at me. So, I'm not going to find this person favorable. And they're leaning towards wanting to deny anyway. And it goes to federal case once. Judge out of Portland, who we both know. And I had a nurse who was diagnosed with Lyme disease. And we barely won the case. We ended up having to have like 4 different hearings on it, supplemental hearings. We could talk a whole podcast about supplemental hearings. But we had literally having 4 hearings on it. And I was arguing through the teeth about Lyme disease. And this nurse had flown all over the world to go get treatment from out of state, out of country, to find the best. She was a nurse, find the best doctors in the world to help. And literally what the judge said was, that's what makes her credible. All the other things is just muddy the water. Like the medical records, why we have 4 hearings. I'm so confused because these medical records are I got fibromyalgia, I got chronic fatigue, I got Lyme disease. Which one is it, Mr. Evans? I don't find this credible. I don't find this not credible, but this is not meeting the criteria and blah, blah, blah. And I'm like, Judge, I'm sorry, I can't force these doctors to write the perfect medical record for you to make it fit right into your square peg. I mean, it's a triangle or a circle, but it's not square. But look what she's done to try to get better. And ultimately, she went back to work to be a nurse because, to our point earlier, she can make $120,000 a year as a nurse and, 50, 40 grand a year as on Social Security. But did suffer from Lyme disease, to your point, intermittent. And that was part of the problem. She'd go to work and then come back off of it and not be able to work. And so this judge really put us through the ringer. But, it's what we do.
Yep.
Go ahead.
Yeah, I was just going to say that's a huge credibility factor. If the amount of effort an individual goes to get better is a huge credibility builder. The more effort they go to, for instance, like with the mental impairments, if they've tried 10 different antidepressants and none of them work, and they've tried them, they're trying to get better. If they're going to therapy every week or, regularly twice a month for, 2, 3, 4, 5 years, why would they spend the money and do that unless they were legitimately impaired,
Right.
So.
All right. Number 8, seizure disorder. I drew this on there. I wanted to talk. I've had a heck of a time with a couple of my recent more seizure cases. And they're looking for, the testing with seizure disorder. You have to actually have a seizure while you're connected to the machine is what makes it a little bit difficult, because everything else then is just a third party usually testifying to, oh yeah, they had a seizure. Or the claimant themselves, if there's no one watching, will say, I had a seizure. This is what happened. I fell down and I woke up, 2 minutes later. And then it becomes a credibility issue. And then if the judge if the judge is leaning towards let's deny, then you're not credible.
Yeah. Well, seizures, and I think they've recently changed the listing for seizures to recognize pseudo seizures. So it used to be with the seizure disorder, you had to have you had to have the classic symptoms, the falling down, the thrashing about, the tongue and the fatigue following a seizure, so on and so forth. But a lot of people have absent seizures, which are considered pseudo seizures, I think. They'll have a seizure that an absence seizure is like losing time for a minute or two. They'll just be kind of out of it, and that didn't used to be recognized, but it is recognized as a type of a seizure. It's not a epileptic type seizure. And it could be that some of these are actually somatoform disorder, which is, more of a mental thing. I don't know, but seizures depend really, unless they're witnessed, it's a very difficult case to prove. And, if you have an EEG that is clean, there's been and which measures your brain wave activity, and there's no abnormal brainwave activity while you're hooked up to an EEG, you don't have the actual proof So then you have to rely on anecdotal evidence, which is, what somebody else saw or what you remember, or, and that gets a more credibility dependent.
Right. Right.
No.
Yeah. So number 9 on the list is, in my opinion, I drew this on there when we were talking about most difficult cases to win, are sometimes child's cases. And the reason I put this on there, I mean, some child cases are really clear cut. So you are a child who is going through a disability. There are very clear cut child cases. Where it gets a little bit harder is sort of like the ADHD, some of the mental health stuff with children. Where it's a little bit easier are the underdeveloped, undergrowth, premature, babies being born. So it's not all child cases are equally difficult. Generally speaking, though, the majority of cases that come to us are the mental health child cases, which can be, not all, a lot difficult, more difficult to win. And the reason is, in adult cases, they go through what's called the sequential evaluation, which is you have to answer, the claimant and the lawyer have to answer 5 questions. One of the third question down is, do you meet or equal the listing? And if you do, you generally just win. It's kind of automatic. Congratulations, you met or equal the listing, you won. You don't even go on to the other 2 questions.
Right.
But if that's no in adult cases, you get to move on to question 4 and 5, and that's vocationally. You may not be meet or equal a listing, but vocationally, you can still prove disability by proving you can't work. So it's not as hardcore like with the meet or equal listing. In a lot of ways, when it comes to your personal, like, health and well-being, you almost don't want to meet or equal a listing, because sometimes that means you are literally on death's door. So the trade-off is, great, like, no one thinks I'm on death's door, or no one thinks, and that's not every case, but, in every listing, I mean, or you're not that severe to meet or equal, but you're severe enough to not work. So you can win by proving you can't, your disabilities interfere with your ability to work.
Well, a 5-year-old,
yeah,
you don't ask if a 5-year-old can work,
correct. So you can't win. You can't get past the listings. It's yes or no, and if it's no, you lose. If it's yes, you win. And so that's what makes it harder. And then the second part of kids' cases that make it hard is, not only is it medically do you have to meet a listing, there's a financial criteria, because it's SSI, because the kid has not paid into Social Security. We don't expect 5-year-olds to pay in Social Security. So then they look at the parent's income.
Yeah. Well, the other thing, Peter, on your first point, is that how it's the cases, the most difficult child cases are behavior dependent. So if you have a child who has, let's say they're on the autism spectrum, or they were born either drug or alcohol addicted, the parent was, they're going to have a lot of behavioral issues. And if you don't have that kind of evidence, and the child is behaviorally challenged, I should say, then you have to kind of look at the parents and the parenting that child is receiving. And it wasn't that unusual when I was a judge to see where children that would manipulate their parents. They had, and this, bear in mind, this was 10 years ago. When did I stop? 2015. So it was 9 years ago. I think that parents, what did they call them then? Helicopter parents or something. It's like parenting was a little different back then. And I'm not quite sure in what ways specifically, but I do recall seeing cases where a child behavior was very bad, very, angry, defiant, those sorts of things. And So the judge is going to sit there and think, well, it sounds to me like, this child is manipulating you, mom. Not that I would say that. I'm not saying that, but I'm saying you run the risk of that when it's just a behavioral issue more than anything. That's why it's good to get school records from the teachers and so forth on those cases.
Well, yeah, you and I could probably talk for a long time about parenting. But as a parent of two young kids and you having grandbabies now, but I think what makes it hard to win, back to the premise, is that the amount of records you need to prove your case. If it's a child's case, you need, like you said, you're not only going to need school records if you have school-age children who are applying for Social Security disability, but you're going to need medical records. You're going to need supportive psychiatrists, psychologists if it's a mental health issue, medical doctors if it's a medical issue, objective testing. I mean, it is not just showing up to court and just saying, hey, my kid has ADHD.
Right.
And, they have ADHD and my kid should be found disabled, and you have very minimal records. You need to come in with a lot of records. The other thing that makes his cases hard to win, and I'm not saying right or wrong, but I've seen judges, and judges fall on both sides of this. If the kid is old enough to communicate verbally, well, call the kid in to testify about what's going on. Meaning, mom could be and say, hey, I'm with mom and dad in the hallway. Your kid's represented by your lawyer here. Have your kid come in, and I want to talk to him. Mom can come in, and I want to talk to him, right? All together. And to have your child testify. I've also seen it on the other side where I don't want to talk to the kid. Let's just go. I want to talk to the dad and you, Mr. Evans, and picture where do they meet in equal listing? Outline your theory of the case very closely for me, and so I can figure this out. But if a judge calls your kid in to testify and your kid's 5, I can't imagine. I have a 5-year-old. I can't imagine my own 5-year-old, and luckily, and we're blessed that hopefully, he doesn't suffer from a disability. But having a 5-year-old testify, sometimes is beyond me. Did you have kids testify in front of you or no?
Very rarely. I hardly ever. It's a traumatic experience for an adult, so you can only imagine what it is for a kid. One case, I had a psychologist there who I had observed this. I think the kid was 12, and then give an opinion on that, because it seems like it was a communication disorder. It was a learning disorder. There were like 3 or 4 different things going on for this kid at once. And I let both the parents be in the room with the kid, because I think it made the kid a little bit more comfortable. And I ended up finding the kid disabled based on what the psychologist said, probably more than anything.
As far as I can remember, every kid's case I've ever been in, there's been a medical expert, because it just comes literally down to the listings.
Yeah.
When judges and lawyers start playing doctor, it can get a little bit rough. All right. And the 10th and final thing we put down, and this is